Good morning, friends. Yesterday we observed how we are going to launch the entrepreneur ventures. Now we are going to observe what are the legal challenges we are going to face in entrepreneur venture, and this is comes under the unit number 4. So there is a three ways if you go to observe the product life cycle: introduction, growth, maturity, and decline. Like that, in the process of the entrepreneur venture, inception of the venture is one stage, ongoing venture, that means continuity, growth and maturity, second one, and last one is growth and continuity of the venture. So these are the three phases are there. First one, at the time of the inception or incorporation or formation of the venture, what are the legal challenges is going to face it. Second one, at the time of the ongoing, that means smoothly running the venture, what are the legal challenges faced. And last one, when you are going to your organization or your venture going to growth and continuity in the long run, and what are the legal challenges we are going to face by the entrepreneur venture. So these are the three ways we can observe that. Now we are going to look about the first one, about inception of the venture. So the major legal concepts only we can consider, and we cannot consider small things. The first one is inception of an entrepreneur venture. So there is a 5 criteria are there. First one is laws governing related to the intellectual property. Those are patents, copyrights, trademarks, as well as trade secrets also there. Second criteria, forms of business organization. Already we know in your graduation level there is a different type of business organizations are there, different types, like sole proprietorship, that means a single owner will be there, partnership, 2 or more people as they become owners, corporations, and franchise. In the previous class we observed about how we are going to launch, what are the different pathways of entrepreneur ventures: creating, acquiring, and last one is the franchising. And the third criteria, tax considerations, different type of tax structures is there. Capital formation, that means how you are going to raise the capital. And last one, liability questions. If got any losses, how we are going to overcome the situation. So these are the 5 criteria we are going to address at the time of the inception of an entrepreneur ventures. If you observe the 5th criteria about liability questions, why we think about liability? As per the statistics in India or across the world also, if 100 entrepreneurs start their business, only 20 to 25% is got success, and these ventures only going smoothly, remaining all failure. So that's why at the time of the failure or the venture got the loss, so this type of liability question may be arised. Second one, ongoing venture. So business development and transactions. So at the time in the process, the business is going to develop as well as the transactions are going to increase there. Here there is 2 laws are there. First one is the personal law, and second one is the contract law. Personal law, hiring and firing policies. It means HR policies. Equal employment opportunity conditions and collective bargaining. So these are the comes under the personal law. That means the law related to humans. That means employees and employer, labor relations, trade unions, all those comes under here. Contract law, that means it comes under the venture level. Legal contracts, sales contracts, and other lease related contracts. Third one, growth and continuity of an entrepreneur. Again there is a 3 criteria are there. First one is tax considerations. So state level tax is there, central level tax is there, and local tax is also there. Based on the different type of ventures, it may be changed will be there. Suppose take the example, you are going to run a restaurant, there is no local tax consideration will be there. Only GST is there. So IGST and CGST it will take it. But you are going to run a venture regarding to the minerals. So the royalty we have to pay to the local Gram Panchayat or other officers. Payrolls. This is the biggest hurdle to entrepreneurs who are run in the short or small way. Normally official payrolls or laws related to the wages or pay is different, but practically if you are going to follow those things it's very difficult to us. Like why? Because you are going to cut the PF, provident fund related issues, and you have to pay this one gratuity related issues and labor laws, ESI related issues, and we have to provide the group insurance. These are the things will be there. And another thing is incentives, fringe benefits we are calling that, or allowances we are calling that. What are the allowances based on the category like that. Second criteria is government regulations. First one, zoning. I think most of the people knows about the concept of regarding to SEZ, MEZ. SEZ is special economic zone. MEZ is manufacturing economic zones. So based on the different type of zones, the government given to different type of subsidies or different type of policy related issues will be there. Administrative agencies, regulatory bodies. Suppose take the example, regarding to banking, RBI is a regulatory body. Regarding to insurance, IRDA is a regulatory body. Regarding to stock market, SEBI is a regulator body. And last one is the consumer law. I think in the first semester legal and business environment we learn about the Consumer Protection Act 1986. And another criteria is the continuity of ownership rights. Property laws, as well as the ownership laws, wills, trust and ownerships, and bankruptcy. Whenever your organization is unable to run because of the losses, we can consider it as a sick industries, and we are going from the winding up of a company. Again, in the first semester we learn in the legal and business environment winding up. So you are going to appoint the liquidator, and then you are going to solvency. Those things will be there. Now we are going to observe. Now we can understand what are the legal challenges faced by the entrepreneurial ventures in the different phases. First one is at the time of the inception. Second one at the time of the ongoing, and third one at the time of the growth and continuity of the venture. So these are the three phases are there, and at the phase wise the venture is going to face the different type of legal issues. Now we are going to observe about the first phase, that is intellectual property protection. In that first one we are observing about the patents. Patent, it provides the owner which exclusively rights to hold, transfer and license the production and sale of the product or process as an intellectual property right. Design patents last for 14 years and all other last for 20 years. That means the validity of the design patents are 14 years and remaining all 20 years. What are the items qualify for patent protection? Everything comes under patent, or some of the criteria is there. Processes, machines, products, plants, composition of elements and improvements on already existing items. So these are comes under the purview of patent protection. And in the US there is a USPTO is there, United States Patent and Trademark Organization. So most of the patents is going to register is there. In India also we have the one patent organization are there, and some of the agents will help you how you are going to register a patent. So how we are going to securing a patent? First one, pursue patents that are broad or commercially significant and offer a strong position. Prepare a patent plan in detail. Have your actions relate to your original patent plan. Establish an infringement budget. That means infringement budget means if somebody obligated that patent is not related to you and it is related to others or it is related to that person, then what happened? You have to prove that one the patent is related to you only. So at the time of the process of proving, you have to take care about some of the amounts or some of the capital that will comes under the establishment and infringement budget. Why? Because you have to your expense is going to increase in the process to get the patent, additional cost. Evaluate the patent plan strategically. Patent application. So to get in the patent process, first we are going to get the patent application. So what are the elements we have to provide in the patent application? First one, specifications. That means the text of a patent and may include any accompanying illustration. Second one, claims. Series of short photographs and identify particular features or combination of features. So this is the process, the patent process from application to allowance and issue. So entire process we are going to divide into the 3 stages. First one, pre-examination. Second one, examination. And third one, post-examination. So if you observe the pictures, you can clearly understand how much time it will take to complete the post-examination. So after the post-examination also it will take almost 2 months. So the total time taken once you applied it almost related to 24 months. That means more than 2 years. And budget almost in the process of the dollars, $2,300. So enter the patent application process. We have 3 stages: pre-examination, examination and post-examination, and it will take almost the 24 months, that is 2 years, approximately 2 to sometimes it will be taken more than 2 years also. Next concept is copyrights. So what is the meaning of the copyright? If you observe about our textbooks or research papers or others also, they clearly mention about a circle. In the circle there is a small C is there. That means the text is copyrighted, registered under the Copyrights Act. In India there is a Copyright Act is there in the year 1970, Indian Copyright Act 1970. So based on that they are going to provide the copyrights towards the owners. It provides exclusive rights to creative individuals for the protection of their literary or artistic productions. And the duration of the copyright is life of the author plus 70 years. Suppose one person may compose a song or write a poem or a song. So that means what is the durability or duration? So the owner's life. So it's what is the age he live and plus 70 years. The copyright owner has the rights to reproduce a work, prepare derivative works based on one, distribute copies of the work by sale or otherwise, perform the work publicly, display the work publicly, sell or transfer individual rights, and copyright production. The material must be in a tangible form so it can be communicated or reproduced. It also must be the author's own work and the product of his or her skill or judgment. Formal registration of a copyright is with the Copyright Office of the Library of Congress, but here in India there is a copyright patent organization is there, office is there, and under the Indian Copyright Act 1970 you are going to register your artistic as well as the linguistic creativity. And what is the meaning of the fair use doctrines and product ideas also? Even ideas also you are going to protect. Here observe fair use doctrine, that means reproduction of a copyright work for purposes such as criticism, comment, news reporting, teaching, scholarship or research is not an infringement of copyright. Protected ideas. The Copyright Act specifically excludes copyright production for any idea. It is not includes, it is excludes. That means not registered. Idea, procedure, process, system, method of operation, concept, principle or discovery, regardless of the form in which it is described, explained, illustrated or embodied. Trademarks. I think most of the people knows what is the meaning of the trademarks, and now we are in the lockdown. If anybody have the Britannia Good Day biscuit packet, they can observe in the name of the Britannia there is one circle is there. In inner circle there is capital R is there. That means it is a registered. And some of the things they are observed, there is a capital TM also is there. So that is TM means it is already got the trademark, and R means it is under the process of the registration. Now we are observing what is the meaning of the trademark. It is a distinctive name, mark, symbol or motto identified with a company's products and registered at the patent and trademark office. What are the advantages? Is it is a nationwide constructive notice of the owner's right to use the mark. Bureau of Customs protection against importers using the mark, incontestability of the mark after 5 years. Current registrations are good for 10 years with the possibility of continuous of renewal of every 10 years. A trademark may be invalidated in 4 specific ways: collection of proceedings, cleaning out proceeding, abandonment and generic meaning. So how we are going to avoid the trademark pitfalls? This is very important. Maybe there is a possibility to ask in short questions. Rule number 1. Never select a corporate name or mark without first doing a trademark search. In this purpose, the website it provide already registered trademarks list available. So based on the list, you can select whether what is the trademark you are going to register is already registered or not. That means the name is available or not. I think most of the people at the time of the creation of Google Gmail, so sometimes you write something, they shows the mail already existed. That means you are going to create another. So to avoid that one, there is a one database available. All the registered trademarks name is there. Rule number 2. If your attorney says, here attorney means lawyer or legal expert, says that you have a potential problem with a mark, trust his or her judgment. Seek a coined or fanciful name or mark before you settle for a descriptive or highly suggestive one. Whenever marketing or other considerations dictate the use of a name or a mark that is highly suggestive of the product, select a distinctive logotype for the descriptive or suggestive words. Avoid abbreviations and acronyms wherever possible and when no alternative is acceptable, select a distinctive logo type in which the abbreviation or acronym appears. Trade secrets. Business process and information that cannot be patented, copyrighted or trademarked but makes an individual company unique and has value to a competitor, that could be a trade secret. That means the process and information which we cannot patent, copyright and trademark but still it related to companies unique and it is value to their competitors, those things we can consider as a trade secrets. Most of the times information is considered a trade secret when if it is not known by the competition, if the business would lose its advantage if competition were to obtain it, if the owner has taken reasonable steps to protect the secret from disclosure. So some of the examples we can understand here what is the meaning of the trade secrets. Customer list, strategic plans, research and development information, pricing information, marketing techniques as well as production techniques. How we are going to protect trademark on the internet? Cyber laws as well as domain names. Next one, identifying the legal structures. This is the